Welcome to ERA's 30 Years, 30 Cases video podcast. We are highlighting important landmark rulings of the Court of Justice of the European Union, as well as landmark opinions of its Advocate Generals, as part of the celebrations marking the Academy of European Law's 30th anniversary. My name is Ramin Farimpour, and I am a senior lawyer and course director in ERA's European Criminal Law section. In this video podcast, we will be looking at the joint case of and judgment in Aranyosi and Căldăraru from 2016. The case dealt with a request for a preliminary ruling on whether Article 1.3 of Framework Decision 2002-584-JHA on the European arrest warrant and the surrender procedures between member states must be interpreted as meaning that when there are strong indications that detention conditions in the issuing member state infringe Article 4 of the EU Charter of Fundamental Rights in relation to the prohibition of inhumane or degrading treatment, the executing judicial authority must refuse surrender of the person against whom a European arrest warrant is issued. The CJU held that if, after a two-stage assessment, the executing judicial authority finds that there is a real risk of an Article 4 violation for the requested person once surrendered, the execution of the European arrest warrant must initially be deferred, and where such a risk cannot be discounted, the executing judicial authority must decide whether or not to terminate the surrender procedure. It can be deemed that this judgment affects the system of mutual trust upon which the principle of mutual recognition in EU criminal justice is built and has a lasting impact on the use of and preconditions in relation to the issuing and execution of an EAW. I now have the pleasure of handing over to Dr. Florentino Gregorio Ruiz Yamuza, who is a senior judge at the Appeal Courts of Huelva and a member of the Spanish Judicial Network for International Cooperation in Criminal Matters. He will delve into more details about the importance of the landmark case of Aranyosi and Căldăraru and frame it within the wider context of the still ongoing discussion about the European arrest warrant and possible grounds for refusal to execute it based on detention conditions in certain issuing member states. I hope that you enjoy the video podcast.
Thank you very much. I'd like to start by expressing my thankfulness to the European Law Academy for this kind invitation to present on this series of podcasts, 30 years, 30 cases, on this genuine milestone of the European Court of Justice jurisprudence, Aranyosi and Căldăraru joint cases. This is a very important case, crucial to understand the interplay between fundamental rights and cooperation in the area of freedom, security, and justice. There are at least three ingredients making this case of such an outstanding importance. The first one is the remarkable legal context. The second one is the relative novelty of the issues addressed by the court. And the third one is the originality of the court decision itself. We are going to very briefly go over the factual background of the case. Later on, we'll comment on the court decision. And we are going to close by making a mention or a reference to a subsequent European Court of Justice case law, and with a couple of questions regarding the future, what the future could be like stemming from that very important judgment of the court. As for the factual background of the case, we're going to start by briefly summarizing what were the facts behind the decision of the court, or the facts giving rise to the decision of the court. The background of the two cases, Aranyosi and Căldăraru, were very similar, so it was a logical decision to join the cases and broach the two of them all together. In Aranyosi, Mr. Aranyosi is a Hungarian citizen that was sought by Hungarian authorities to serve a prison sentence in Hungary for 2 counts of burglary. So when that person was arrested and brought in front of the High Regional Court of Bremen, the public prosecutor asked the Hungarian authorities whether Mr. Aranyosi was going to be kept in pretrial custody, and should that be the case, to what prison he was going to be sent to. Two points that the Hungarian authorities said that it wasn't sure that Mr. Aranyosi was going to be sent to pretrial custody, and in that case, they weren't able to say to what facility he was going to be sent. The situation was a bit subtle because there were some information, there were a series of informations suggesting that conditions in Hungarian prisons weren't good ones, because there was a string of decisions from the European Court of Human Rights, and there were some reports of the Committee of Prevention of Torture suggesting that the conditions in Hungarian prisons were substandard, and that there were likely to appear infringements of fundamental rights because of overcrowding, because of lack of hygienic conditions, because of lack of heating or warm water or something like that. Even though the public prosecutor was in favor of the surrender of Mr. Aranyosi, but the defense raised those points. That in parallel, the Mr. Căldăraru case, Căldăraru was requested to stand trial in Romania for a traffic offense of driving without license, but the situations in Romanian penitentiaries were more or less similar to those of existing in Hungary, and there were decisions from the European Court of Human Rights, and there were reports from the Committee for Prevention of Torture. So the court in Bremen, the Overlandgericht, Hanseatische Overlandgericht Bremen, decided to sought guidance from the court in Luxembourg, from the European Court of Justice, via a preliminary ruling reference. And the 2 points that the preliminary ruling reference posed were the following. The first one: is there any legal ground supporting, according to Article 1.3 of the framework decision of European arrest warrant, in relation to Article 3 of European Convention of Human Rights and Article 4 of European Charter of Human Rights? Is there any legal reason that allows the court to not surrender a person when to refuse the surrender in the case that there is a risk of a violation of those fundamental rights? And the second question is, can or must the executing member state lay down a specific minimum requirements applicable to detention conditions and ask for any kind of assurance, meaning that can the executing member state impose a kind of obligation on the issuing member state to assure that the detention conditions were going to be in compliance with the European Convention of Fundamental Rights and a Charter of Fundamental Rights of the European Union? These were the two questions. We're going to enter now to the legal context, because the legal context is a very important one as well. These two questions were like a resounding question, but not exactly a bolt from the blue, because it wasn't the first time that the European Court of Justice in Luxembourg was facing the balance or the interplay between fundamental rights and mutual recognition and mutual trust principles. Was not the first time, but the perspective was a new one. The legal context is very important, because the legal context talks us about the relationships between the case law of the European Court of Justice and the case law of the European Court of Human Rights. The European Court of Human Rights has jurisprudence regarding systemic deficiencies, and has a jurisprudence telling us in Soring versus United Kingdom, telling us that the extradition cannot be shall be in compliance with Article 3 of European Convention of Human Rights. So this case law of the European Court of Human Rights was very important for the European Court of Justice to make its decision. And additionally, there was a relationship between the two systems, the system of the European Convention and the system of the Charter, via the Bosphorus presumption, as we know that the protection is similar in both hemispheres, let's say. And there were a series of interesting decisions from the European Court of Human Rights. The most important probably is Avotins versus Latvia in May 2016, telling, or afterwards, Romeo Castaño versus Belgium, telling us that not always when applying European Union instruments or legal texts, the situation is automatically going to be in compliance with fundamental rights. So we need to check on a case-by-case basis. It's a presumption, rebuttal on a case-by-case basis. As for the jurisprudence of the European Court of Justice, there had been a lot another judgments taking into account the interplay between fundamental rights and mutual cooperation, such as Advocaten for Vedel or Meloni case, or even Radu case. And we had a very important precedents as well in NS cases, an asylum case, where systemic deficiencies were at stake as well. So when the case came to the European Court of Justice, there were two positions. The positions of the Advocate General, that was in favor of broaching the matter from the perspective of proportionality, and he tended to say, well, let's examine and analyze the proportionality, and the Article 1.3 of the framework decision of the European arrest warrant is not a ground for refusal. So let's examine the matter in the light of proportionality, and that way mutual trust will be intact. On the other hand, the position of the court was more straightforward. The court says, well, we have a legal framework, Article 1.3 of the framework decision, Article 4 of the Charter 3 of the European Convention of Human Rights, and Article 6 of the Treaty of European Union. So let's say Article 1.3 is not exactly a ground for refusal, but we cannot get rid of that. We cannot forget about that article. We are pretty much concerned about the situation in Hungary and Romania, and we need to perform a two-tier or two-pronged test. So seeking the situation in a general in the country and examine if in the particular case fundamental rights are going to be infringed or violated. And the court also bear in mind the judgments of the European Court of Human Rights, the reports of the United Nations and other sources of information, and even consider the possibility of a postponement of this surrender while the information is pending to be collected. It was this scenario. This was the rationale of the judgment of the court. And here it comes, the operative part of the judgment. The operative part says, if there are systemic or widespread shortcomings that affect certain groups of people or certain prisons, the executing member state authority must verify concrete and precisely the circumstances of the case. It will request additional information, and the surrender will be postponed until such additional information is received. And this is very important. If the risk cannot be excluded within a reasonable time, the executing member state authorities shall decide whether the surrender shall be brought to an end. Commentary of this sentence, we have to say, this is not the first time that the European Court of Justice had this problem of the interplay between fundamental rights and mutual recognition principle, or on top of its table, but it's the first time that in a manner so straightforward and so clear, were confronting the protection and preservation of fundamental rights of absolute content, those that cannot be infringed or violated under any circumstances, and the application of the mutual trust principle. So the court made an effort to compatibilize the case law of the European Court of Human Rights and its very own jurisprudence, and was very aware of it was required a two-level assessment, a two-pronged test, and decided what is a big leap in the jurisprudence of the court in Luxembourg, decided that if the risk persisted, we need to decide whether or not the request the extradition was going to be granted or not. But the decision, which is a very important one, is implied a significant step in the protection of fundamental rights, left a series of questions unsolved. Those questions are, for instance, what about the unofficial sources of knowledge regarding the situation of fundamental rights in any given country? Another point is what about the initiative and burden of the proof. Was that on the issuing member state, on the executing member state authorities? Was that on the counsel for defense? Was that a task for the prosecutor? That matter wasn't that clear. Another thing which is important is the ground for postponement and time limits. The ground for postponement didn't exist. That idea of halting the extradition proceedings was a novelty. And what about the time limits of the European arrest warrant from a decision? Another important thing, probably the key issue here, was why the court didn't mention the possibility of refusing the surrender. The court did later on in LM case, for instance. And the questions that in 2016 might have scared us a little bit more were that of, might this judgment amount to undermine cooperation based on mutual trust, or might it favor impunity? Because avoiding impunity is like a mantra of the jurisprudence of the European Court of Justice. So we didn't have, and we still don't have, a principle that tell us addedere aut judicare, either surrender or try the matter, or either surrender or enforce the sentence imposed. Lacking that principle, lacking that legal provision, the situation of Aranyosi or Căldăraru place us on top of the cliff, at the brim of the cliff. Well, later on, I'm going to finish with the subsequent case law. Later on, after the years, there has been another judgments and other decisions from the court, such as ML case or Dorobantu, but the most important in my view is LM case. In LM case, what was at stake wasn't the fundamental rights of absolute content, but was the right to a fair trial. And then the court followed the path established in Aranyosi and Căldăraru, but with significant differences. For instance, the court was stressing the idea that since we are not in front of absolute fundamental rights, we need to be more strict, so to speak, examining the situation or the risk running by the fundamental rights, meaning that fundamental rights of absolute content admit no infringement at all, whereas the fundamental rights to a fair trial deserves to be examined to what point there was going to be a flagrant denial of justice, in the words of the Advocate General, or the breach of the essence of the right to a fair trial, in the words of the court. Another important difference between LM and Aranyosi and Căldăraru is that in LM, the court, instead of saying must decide whether to surrender, the surrender procedure should be brought to an end, the court said that persisting the risk of the significant breach of the right to a fair trial of flagrant denial of justice, the court must refrain from giving effect to the European arrest warrant relating to that person. So the court says, if the risks cannot be excluded, you don't cooperate in that matter. So this is very important among other aspects of the judgment in LM, that, for instance, that the procedural ones following the path in ML and other technicalities, is very important that how the court evolved from Aranyosi and Căldăraru to LM. So I'm going to close with two small and brief questions, but which are very important in my view. Seeing as from Aranyosi and Căldăraru to LM, we have witnessed the evolution of the court in this fundamental matter of interplay between fundamental rights and mutual trust and mutual recognition principles. Can we ask ourselves whether in a future that case law could be applicable not from absolute content fundamental rights to non-absolute content fundamental rights, but not only to the right to a fair trial, but to any kind of fundamental rights in the Charter of Fundamental Rights of the European Union? My opinion is yes. In the future, we're going to see an European arrest warrant where it's at stake the situation or the conflict or the interplay between mutual cooperation and the right to a family life, or mutual cooperation and the right to another right in the Charter. No, it's not just a thing of fundamental rights of absolute content and right to a fair trial. So any fundamental rights could be invoked along with that doctrine in Aranyosi and Căldăraru and LM. And the second question, which is even more important in my view, is that doctrine that stemmed from NS case in a way, that always have into account the existence of a double level of deficiencies at the systemic level, but that may impact on the specific case, is a general situation, but also a ad casum analysis that has to be performed. What if we're not facing a scenario where there are systemic deficiencies, but just a deficiency in the particular case? For instance, if we are going the situation where the right to a fundamental trial has been infringed in the case without a systemic or generalized scenario. There are two questions to reflect, and by saying that, I'm finishing. Thank you very much for your attention. Thank you very much yet again to the European Law Academy for its invitation. Thank you very much.